Hello, everyone, and welcome to the Year in Review Regional Roundtable Series, brought to you by the Employment Law Alliance, the world's largest network of labor and employment lawyers from the best law firms around the globe.
Hello, my name's India Townsend and I'm a Senior Associate at Simpson Grierson in New Zealand. Thank you for joining us today. In this vlog, I'd like to talk to you about the developments in 2022 in the legislative and case law space, and also give you a heads up as to what we're expecting to see in 2023. So firstly, what were the most significant legal changes in 2022 that impacted employers? I'll start with the most impactful change, which was the enactment of the Fair Pay Agreements Act at the end of last year. My colleague Rachel Judge has done a separate vlog on this specific topic, but in essence, fair pay agreements are a form of industry-wide collective agreements that will sit alongside individual employment agreements and collective agreement, a minimum floor of rights for all employees in a particular occupation or a particular industry. The thresholds to start a fair pay agreement application are incredibly low, so this will have a huge impact on employees. It's much wider than initially anticipated. There are already 4 fair pay agreement applications on foot. However, it is election year in New Zealand this year, and so it remains to be seen what will happen with the Fair Pay Agreements Act and the fair pay agreement applications that are currently on foot, given the opposition party has very strongly said that they will repeal this act if it comes into power in October. The second main development is the Uber case, which was released at the end of last year. So in this case, the Employment Court reached a firm conclusion that 4 Uber and Uber Eats drivers were employees and not independent contractors. So how will this impact employers? Well, it reflects a growing trend towards the correct classification of employees and ensuring their minimum rights are protected. The Chief Judge's overall approach will likely make it easier in future for contractors to claim that they are employees. And also, we consider that it confers a greater discretion on courts to make that finding. The issue is that this case actually reached a different outcome to another Uber case, which was released the year earlier. So this really is an unsettled area of law at the moment. And so Uber is appealing the most recent case, and we await that judgment. So moving on to 2023. In terms of horizon gazing, well, the government has an extremely busy legislative agenda for 2023 and are trying to get through as many pieces of important legislation as they can before the general election in October. And so, rightly so, many employers are feeling very overwhelmed by the amount of change in the legislative space. So very briefly, I'm going to run you through some of the new legislation on the horizon. So we have a new act which extends the amount of time that an employee can bring a personal grievance for a sexual harassment claim. Currently, an employee has 90 days to bring a personal grievance, but if this act passes, which we expect it will, employees who have a complaint of sexual harassment will have 12 months rather than 90 days. Another interesting act, which is very initial stages, is the Employment Relations Restraint of Trade Amendment Bill. Now, this hasn't even had its first reading, but already it is causing shockwaves amongst employers as it is currently proposed, because the proposal is to prohibit the use of restraints of trade and employment agreements for low and middle income employers. In relation to non-solicit and non-compete restraint of trades for higher income employers, it proposes to permit these when they are necessary, but only if employers compensate the employees at least half of their weekly wage for the duration of time that the restraint is in effect. The bill also proposes to limit restraint of trade durations to 6 months maximum. So this does have employers worried, particularly the prospect of not being able to put a non-solicit restraint in some of those middle income employees who have access to clients. Another scheme which was at the forefront of the government's agenda has just been scrapped, and that was the income insurance scheme. That has been decided not to proceed with this term, and that essentially was a mandatory nationwide income insurance scheme or equivalent to a statutory redundancy compensation type arrangement that we see overseas a lot, but that has been scrapped, and so the position remains that there is no statutory redundancy compensation or income insurance scheme in New Zealand as of yet, but don't totally drop that one for now. So look, to recap, election year is always a lively period from an employment law perspective with a busy legislative agenda ahead. We're also awaiting some important case law on the vaccination space and also that appeal on the Uber case. So listeners need to keep an eye out for key developments in this space. I'm happy to answer any legal questions you have on this topic. Again, my name's India Townsend. You can find further information and my contact details in the bio below. You can also find me on the Find a Lawyer section on ELA's website. Thanks a lot.